morning, Your Honors. May I reserve 5 minutes for rebuttal? Thank you. May it please the Court, my name is Adam Sudbury, and I'm here representing EUGENIO ACEVEDO in this case. Mr. ACEVEDO, this is an appeal from the Ninth Circuit Court in Orange County, was convicted of driving while license revoked as a habitual traffic offender. The historical facts in this case are as follows. On or about August 4th, 2005, Deputy Bullinger of the Orange County Sheriff's Office observed a vehicle traveling, conducted a traffic stop on that vehicle. Later, it was discovered that the person driving the vehicle was Mr. ACEVEDO. Search of his license revealed that his license had been revoked as a habitual traffic offender, and he was arrested. This case went to trial in November of 2005, where there were several evidentiary issues raised at trial, the main one of which is whether or not the state adequately proved the third element of the crime, which is that notice was given as required by the statute. I think the first issue that is important to address, and which was raised in the state's answer brief, is whether or not notice is an actual element of this crime. The state has cited two cases, the Spruill case and the Card case, which seem to suggest that there are only two elements in driving while license revoked as a habitual traffic offender, one being that the defendant was driving, and the second being that his license was in fact revoked. And I would suggest to the court that under the standard jury instructions, there is in fact a third element listed. That element was instructed to the jury by Judge O'Kane. In Spruill and in Card, the notice element, which is in the standard jury instructions, is in fact part of the revocation element, the fact that the license is revoked, because to have a valid revocation, notice must be given. And there's two cases that address this in particular. One is the Fields case out of this court, which is at 731 Southern 2nd, 753, which cites and discusses the Chacon case, which is a Supreme Court case at 684 Southern 2nd, 736. And Chacon stands for the proposition that we're never to infer that a crime is a strict liability crime, that the focus is on legislative intent. And Fields talks specifically about driving while license revoked as a habitual traffic offender and discusses the fact that the legislature specifically identifies notice as being that state of mens rea, that notice is in fact the measure of knowledge required by the legislature based upon the statute. And
the requirement that notice be given or that notice be received?
The requirement is that notice be given and that the state adequately prove that notice is given. And that's specifically stated in Fields. There's no way to argue that, they have to prove that notice was received. But they do have to prove that notice was given. And in the jury instruction and the statute, notice is specifically defined. They have to prove that a letter was mailed, placed in the mail, letter was marked certified mail, postage prepaid, sent to the last known address of the person whose license is being revoked. Now, under the statutory scheme, it specifically states that an entry in the driving record is sufficient proof of notice and that it's admissible in all the courts of the state. So, to the extent that I've argued that hearsay somehow excludes that, I would withdraw that argument at this point because I have looked again at the statutes, and the statutory scheme precludes any state evidence code arguments that could be made. However, a statute that says something is admissible cannot be used to overturn the U.S. Constitution and the confrontation requirements of the U.S. Constitution. So to the extent that this is a testimonial statement that notice is given pursuant to Section to to the section dealing with notice, I think it's 316.251 or 322.251, then it would have to be excluded because the U.S. Constitution and the U.S. Supreme Court's opinions override any state statutory scheme that might make it admissible. So the question really is what is the nature of this statement, this short cursory statement included in everyone's driving record in any driving record where there's a suspension or a revocation. And in order for something to be subject to confrontation and subject to Crawford and later cases that discuss Crawford, there have to be three things. One, it has to be a statement made by a witness. And the second thing is that it has to be offered at trial or used to prove a fact. And the third thing is that it has to be a statement of a nature where a reasonable witness could expect that it could be used prosecutorially. And here, we have a statement that notice is given, and we know that's made by a witness because presumably someone entered this into the driving record at DMV. There's an actual physical person out there who mailed a letter, or presumably mailed a letter. We actually don't know if the letter was mailed because no one testified that they mailed a letter. But presumably there's someone that entered that statement into the driving record. So there's a witness that's telling the jury in this case that a letter was mailed. And that was clearly offered to prove a fact because it was offered to satisfy the third element of this crime. That's the only reason it was offered at trial. The only reason for its inclusion in the driving record, in fact, is to prove this in a later proceeding. So the question ultimately is whether or not a reasonable witness could expect this statement to be used prosecutorially.
Mr. Sudbury, how does this case distinguish itself from Card?
Your Honor, in both Card and Sproul, where it was held that the driving record is not testimonial, those cases specifically address the driving record itself and not the testimonial statement contained within the driving record.
That notice was given.
That notice was given. Moreover,
doesn't it say this individual was convicted of a speeding violation on such and such a date in such and such a county?
Correct.
Is that any more or less testimonial than a letter was sent out telling this person the license has been suspended or revoked?
Well, the cases out of the district courts suggest that it's less testimonial because, excuse me, or it's not testimonial at all. My personal belief is that it is, in fact, testimonial because it's referring to, it's being used to prove these past events. But it would, in fact, be less testimonial because it's a mere clerical recording of a conviction or of the outcome of a court proceeding. And supposedly there would be, certified records at a court that someone could go back and actually discover what happened to that speeding ticket. Here, we have an unidentified witness at DMV, and no one knows who this person is. This person has not sworn to a single fact. There's no affidavit. There's nothing. This is far less reliable than even the types of things that the Supreme Court has said are clearly testimonial, like affidavits, sworn police testimony, and such. I was never able to ask anybody, despite wishing to, whether or not they sent this to the person's last known address, where this was mailed to, how it was mailed. Was it done on a Friday afternoon? Is it handed off to someone else to be put in the mail? Could it have gotten lost? We have no way of knowing these things because we don't even have a witness. I don't even have anyone I can depose. I don't have anyone I can call at trial to ask whether or not it would be more beneficial to mail something certified mail, to mail something FedEx. There's no one here. It's just a statement by an unknown person in the driving record that they're using as the only proof to prove that third element. May I reserve it for rebuttal? Thank you, Your Honors.
Good morning. May it please the Court, Mary Jolly on behalf of the State of Florida. I think my response brief, he's re-argued basically what's in his brief. I think the brief covers the issue, and unless this Court has any other questions, I'll rely on it. I do just want to add with respect to notice, the legislature has created a statute 322251 which addresses the issue, and I think that covers it. Unless the Court has any other questions, we ask you to affirm in all respects.
Well, in his reply brief, he attempts to distinguish Card and Spruill in the application of those two cases. Why don't you respond to that?
That's fine. Card covers the hearsay part of it. I think that the confrontation aspect of it. The annotation in the record is a part of the driving record, and I think Judge Evander made a nice analogy that it's not testimonial, so it doesn't fall under Crawford. So I think Card embraces that. It falls under that umbrella as well. It's non-testimonial, Judge, so it doesn't fall under Crawford. So there's no problem. And then the proof of notice is covered by, the legislature covered that in 322251. There's just no issue here, I think, in terms of notice. And it's the state's, and we adhere to our position that Arthur, a case which came out after Fields, sets forth what the elements are of the statute, and the jury instruction is going to be corrected to eliminate that because it's not an element anyway. So I think my brief covers all of those issues. And if that answers your question, we'd ask that you affirm. Thank you very much.
Your Honors, the state has claimed that blanket statement, this is not testimonial. It really hinges on that third element of whether or not this could be expected to use prosecutorially. There's a case that's come out of the U.S. Supreme Court after all the briefs were submitted called Davis versus Washington, which
Have you offered that as supplemental authority?
I haven't here. I apologize, but it expands on that. I would
just as a matter of professional courtesy, we'd ask you not to argue it since opposing counsel hasn't been given notice of it. But if you'd like to submit it as supplemental authority, you can do that.
Yes, Your Honor, I will do that. In any event, if under Crawford itself, the standard is whether a reasonable witness could expect it at some later time to be used prosecutorially, not whether or not it was prepared for the purpose of prosecution, which is what the trial judge in this court ruled on. And there's a case out of, I believe it's this court, it's the Johnson case, which discusses breath test affidavits and goes into those same issues as well on the issue of breath test affidavits. And I would just like to finish by saying that these crimes, these driving crimes, driving while license revoked as a habitual traffic offender, this is not something that only people with DUI manslaughters and fleeing cases. A lot of these people out there are having their license revoked and being charged, convicted, and sent to prison on felonies for simply having civil infractions for driving with a suspended license. And 3 convictions for civil infractions or misdemeanors can get your license revoked. And to simply take away all elements of knowledge when there's a clear legislative scheme, Supreme Court jury instruction that says this is the standard for knowledge, this is what the state has to prove by competent evidence, to just take that away for something that's a felony is simply unfair. And for those reasons, we would ask that the court reverse Mr. ACEVEDO's conviction and order that he be discharged. Thank you very much.